The government has shown it can't even abuse the constitution competently.
Go on.
The whole exercise is like a illustration of their ineptness over Brexit. The idea, a clever idea in certain circumstances, was to suspend Parliament, to close down Parliament, not just put it in recess, but actually lock the doors, stop the select committees, stop everything for 5 weeks with this ancient power, which is usually just used for starting a new parliamentary session. It usually just only happens for a few days. But somebody had the bright idea, let's close Parliament down for 5 weeks and stop MPs doing anything during this national crisis. And on the face of it, they had a legal power to do that. And my initial view is that there was zero chance of this being legally challenged. Because it's usually one of those little parts of the Constitution which isn't used very often, and the Queen has the power to prorogue Parliament because Parliament sessions need to start and end, and new Queen speeches and things like that. But it was litigated. And the argument against the government was that they were acting in bad faith, so-called improper motive. And usually, when you are faced as a government with a legal challenge on the basis of improper purpose or bad faith, all you really need to do is put down a witness statement from a minister or a senior civil servant just explaining how the decision was made. And that is what should have happened. But just like that dog in that Sherlock Holmes story, the curious incident when it doesn't bark,
yes,
for some reason a witness statement was not put in the Scottish case. And that has turned out to be crucial, because in the absence of an account by the government of why it took this decision to prorogue Parliament, and remember the official version is that it's to prepare for a new Queen's speech.
Yes.
It became open to the Scottish judges to infer that in the absence of a positive, plausible explanation, that there was a bad motive, and that it was being done to stop parliamentary scrutiny. And having found that, they've made what's called a declaration. I'm not a Scottish lawyer, and Scottish law is very different from English law.
What? I thought Brussels set all our laws.
No, in constitutional law, Scotland's very different from English law. They have a healthy lack of respect for absolutism on questions of sovereignty.
Well, I never.
And so Scottish judges are usually a little bit more open about, there's no no-go area in the Constitution for us. We're going to have a look at this. And so unanimously, the 3 Scottish judges have said, the only explanation for this prorogation is an improper motive. And if it's an improper motive, it's unlawful. So we're going to declare that it has no effect.
And is that an in the absence of any other account we must conclude, or am I jumping the gun?
We haven't got the full reasons yet. We've only got a summary on the Scottish Judiciary website. The full reasons are going to be coming out on Friday, I understand. But from the summary, it looks like each of the 3 judges themselves took the view that we can only conclude that this was done for an improper motive.
How significant then does that comment, because quite a lot slips through the cracks, doesn't it, as you know as well as I do. How significant then does that observation in last few days from the Northern Ireland Secretary that he'd known nothing about prorogation being on the cards?
I doubt any of the ministers knew about it.
Well, that explains why they wouldn't be able to submit a written account of what had happened, doesn't it?
No, there would be a senior civil servant who would have been in a position to do it. And this is where this was raised by Joanne Cherry on the floor of the House of Commons, and also by Dominic Reeve. The reason why there wasn't a witness statement is because it seems that nobody would risk the legal peril of signing it.
Oh, my days. Oh, my days.
Because it's a criminal offence to knowingly...
So you can send Rees-Mogg and Leadsom and friends around the studios claiming that it's perfectly normal and traditional behaviour, but it is suggested none of them would be prepared to put their name to it because that would have consequences.
And it would appear, I don't know for certain, but it would appear that there is something which prevented somebody happily signing a witness statement explaining the true reason why prorogation was sought. And in the absence of that, it was conspicuous.
And then Dominic Greaves' motion yesterday calling for all communications regarding the decision to prorogue Parliament to be published.
as part of the same thing. It's all part of why can't the government get any minister or civil servant to sign a witness statement under peril of law stating that the true reason that they wanted prorogation was to prepare for a Queen's speech? They can't find anybody to do that.
And they've got cheerleaders in the press saying it's obviously a lie and I love it, which...
But coming back to what I said at the beginning, this was an exercise in choreography. Yes. This could have been done competently, but they couldn't even do this. Could
it though? Because you'd still need to find a minister prepared to put their name to something that...
No, but you were in the run-up to it. You would have made sure that nobody sent stupid texts and messages giving the true reason.
So the reason why we are speculating now why someone wouldn't be able to write down what the reason was, because there might be evidence out there that would render that dishonest. God, you're good.
Effectively, this could have been done, but it's because there's a certain intellectual arrogance in 10 Downing Street. They have these clever ideas,
Euphemism
and they don't impact upon reality very well.
Well, hang on a minute. I thought it was only by hanging around in your tapestry room in London and seeking the company of people who weren't rich Remainers that you could get a full idea of what reality looked like.
Well, God save us from clever people who don't realise they're not as clever as they think they are.
Oh, God save us indeed. So, final question, and you really should do more broadcasting. I know you don't necessarily enjoy it, but you're an absolute gift. You're brilliant. If the appeal in the Supreme Court loses, does it go to the European Court of Justice?
Well, on the face of it, the Scottish judgment has declared prorogation to be unlawful and void.
Yes.
So the next step, actually, is to see how Parliament reacts. Does John Bercow just turn up and open it up like opening a shop in the morning and just wait for the MPs to come back in? Because if the Scottish judgment stands, then prorogation is unlawful from the date the order is made by the Scottish court.
They're working on the presumption that we'll wait until the result. But as you say, there's no precedent for that. So theoretically, Bercow could turn up and throw open the doors and say, come one, come all, we're back in business.
And then the next stage will be the Supreme Court. The Supreme Court is the only court which actually has jurisdiction over both Scottish law, English law and Northern Irish law.
Hence the name.
And they have 2 judges there, including the Deputy President, who are Scottish judges. And it will be their unenviable task to try and reconcile Scottish constitutional law and English constitutional law on this point.
Right. Good grief.
The court in London found that it was not a question for the judges to be able to answer. It wasn't justiciable. That is fairly obvious the English legal position. The Scottish judges have taken a different view. The Supreme Court has got to synthesise that. But no, James, it won't go to the European Court of Justice. It isn't a question on European Union law.
I didn't think it was, but, still. Final, I don't know, I promised that was my final question. You may not be able to answer this one, but there were 3 new, my tireless correspondent this morning, I Am Incorrigible, has reminded us that there were 3 new judges appointed to the Supreme Court on the very day that Boris Johnson became Prime Minister. Does that matter? No,
not at all. There are a very sensible and professional approach to appointing judges in the Supreme Court. I have no doubt that Boris Johnson would like to be like Trump and appoint lots of more sympathetic judges, but that's not going to happen, at least not in any way soon in English.
Not in any way soon. Never say never. Wow. Personal question, David. Are you enjoying this?
Intellectually, yes. It's the most interesting time to be interested in constitutional matters since probably the 1680s. It's remarkable. Constitutional law shouldn't be exciting.
I know.
Constitutional law should be dull.
Yes.
A happy political system is one with no constitutional cases.
And
there
here we are.
Textbooks on constitutional law, James, where there are chapters of books without a single 20th or 21st century case cited.
Good grief.
And now, constitutional law textbooks are about as out of date as last year's tax code. It's astonishing how quickly things are happening.
We're going to need a bigger book.